Hello friends and welcome back to the first edition of the revision series of the JIGL subject for the upcoming December 2025 examinations. Now in this video we're going to be starting out with chapter number 5, that is your law of torts. For those of you who are new to my channel, my name is Anuja and I have been a teacher of the Company Secretary course for the past 8 years. I have designed this revision series to be entirely in English and to cover the entire ICSI module so that you find it easy to revise your chapters right before your examination. Now, in this video, I'm going to be referring to notes made by me. These notes consist of simplified material with respect to all the topics in your textbook, as well as case law sheets, which provide the topic, the case law, as well as the decision. Now, each one of the case laws in the textbook are a little bit complicated or may sometimes have too much information, and I have gone ahead to consolidate all of that information in one place so that you find it easy to access all of these case laws and study them for your examination. So, if you wish to access these materials, then I've given detailed instructions in the description below. Go ahead, follow those instructions, and we will start with the revision of our law of torts. So, what exactly is this law of torts? Well, first thing we need to understand is what is a tort. Now, a tort is nothing other than a French word for the word wrong. Okay, now the word wrong itself has multiple connotations. This is wrong, that is wrong, criminal wrong, civil wrong, um, uh, any kind of wrongs can exist in this world. But when we are talking in relation to our subject, our law of torts, we are talking about wrongs in essentially two forms. One is that it can either be a civil wrong or it can be a criminal wrong. Now, please understand, a tort has nothing to do with a criminal wrong. And so, therefore, we do not look at criminal wrongs when we are looking at the law of torts. Okay. So, if it is a civil wrong, then which civil wrong actually amounts to a tort? Are all civil wrongs a tort? The answer is no. And for this, we need to understand two concepts known as right in rem and right in personam. So, we'll try to understand what this right in rem and right in personam are. Okay. So a right in rem and a right in personam, we have already discussed this when we covered the revision series of our Constitution of India chapter, and we look at it again over here. First, we'll try to understand what is a right in personam. A right in personam is nothing other than rights which are created between two or more people only. So let's say we have two people, Arun and Bhaskar. Now, Arun and Bhaskar are two people who decide to enter into a contract. So, in this contract, we'll make it a very simple contract. Arun has in his part of the contract, Arun has decided to sell goods, and Bhaskar will pay money. So, it's a simple arrangement where Arun is selling some goods and Bhaskar is going to pay money for it. Now, in this entire contract, let's break it down on the basis of its rights and liabilities. Now, it's very simple. We'll write Arun and we'll write Bhaskar. And then we'll write down the rights involved as well as the liabilities. Okay, so when we make a simple table like this, we start to understand what do you mean by this rights and liabilities when we're talking about contract law. So, with respect to Arun, Arun has a right to do what? Arun has a right to receive. So, Arun is selling goods, so he has a right to receive money. Okay, now this is a right. He has a right to receive money, correct? Because he's selling the goods. Now, the same way, what kind of a right will Bhaskar have? Bhaskar will have a right to receive the goods. Now, alternately, what is the liability for Arun? Arun has to send the goods. Because if he doesn't send the goods, then his part of the contract is not being done. And the same way, Bhaskar has to pay the money. So, look at how certain rights and liabilities are being created between two people when they enter into a contract. And this, my friends, is what we call as a right in personam. A right in personam is basically a set of rights and liabilities which are created between two or more people when they enter into a contract or when they trust each other. So we can say that right in personam is basically two types. It can be either formal or it can be informal. What do you mean by formal? Formal would mean a formal contract where two people enter into a formal contract with each other. But then informal can even simply just be trust. Like if Arun and Bhaskar were friends, and then Arun would trust Bhaskar and send the goods, and Bhaskar would trust Arun to receive the goods. So either ways, there is some kind of a right or liability being created over here. And this, my friends, is only the right in personam. So when we come back, as you can see, the right in personam consists of either a contract or a trust. This is what we need to understand first. Then, alternatively, we have the next concept which is known as the right in rem. Now, the right in rem is a very interesting concept because it doesn't work like the right in personam. The right in rem basically states that there is one single individual, and we'll name this individual as Arun. And Arun, being a citizen of the country or a person, an individual, has certain inherent rights given to him. Okay, and there's a concept in law which says that where there is a right, there is a subsequent duty to protect that right. Again, I'll repeat myself, where there is a right, there is a duty to protect that right. So it is believed that every individual in our society, you, me, your friend, your parents, my parents, everyone around us are individuals by themselves. They're a single unit in society. And each one of the individuals have certain inherent rights which are given to them. What are these inherent rights? These inherent rights are only what we call as a tort. But these inherent rights have to be protected by the society. The society has the duty to protect the right. Because as you can see over here, we have the right, and each individual has the inherent right. The duty stays with the society. So that means, let's say, for example, that Arun owns a house. Okay, and this particular house is Arun's. It's his own house. Now, Arun has a right to enjoy his property, live in his house, rent it out, do whatever he wants with the house. And the society has a duty to ensure that nobody trespasses into his property. Correct? So these are what we call, this is one such example of an inherent right. And the thing is that what if a right gets violated, because ultimately everything is about rights and duties or rights and liabilities. So when a right gets violated, that's when we can say a tort has been committed. So let's go back to this concept. A wrong can be either civil or criminal, and we're not talking about criminal wrongs over here, we're only talking about civil wrongs. Civil wrongs itself can be divided into your right in rem and a right in personam. What is a right in rem? A right against the world, right against the entire world. And this is the right which we ultimately call as a tort. Because the opposite of right in rem is a right in personam. A right in personam is usually created between two or more people, whereas a right in rem is naturally inherent in each and every individual. And then this right in personam can be of two types. It can be a breach of contract, which is the much more formal means, whereas a breach of trust is an informal means. Ultimately, it involves two or more people who have created rights and liabilities between each other. So, now the main question comes down to, what is a tort? A tort is a right in rem and it is a civil wrong. Is a breach of contract a tort? The answer is no, because a contract breach of contract is a separate category by itself. Is breach of trust a tort? The answer is no, because again it falls under the right to personam. So we'll try to understand the definitions of what a tort is from multiple definitions. Whether it is Section 2, Clause M of the Limitation Act, whether it is definitions given by jurists such as Salmond, Fraser, or Winfield, we will be looking at each one of the definitions because, in a way, all the definitions have a common element to each one of them. So let's look at Section 2, Clause M of the Limitation Act. This definition is actually very small, but the explanation that I've given will help you with understanding multiple concepts. What does it say? It essentially says that a tort is a civil wrong, and this much we have already established, which is not a breach of trust. Sorry, breach of contract or breach of trust. Is this very simple? It is a civil wrong. A tort is a civil wrong, which is not a breach of contract and not a breach of trust. This is only the definition given under Section 2, Clause M of the Limitation Act. The explanation that I've given to you is for your understanding, because tort only arises when there is a right in rem, and tort does not include wrongs arising out of rights and liabilities arising out of any agreement between two or more people. In essence, in any kind of a contract. Then I've gone ahead to explain what a right in rem is and what a right in personam is. Great. Now let's come down to what Salmond is saying. Salmond is also saying that it is a civil wrong. So that is another common factor to all the definitions. But here he goes ahead and talks about a remedy. See, if there is a tort being committed against you, what is the remedy that you're going to get for it? Here, Salmond is saying that the remedy is an action for unliquidated damages. What do you mean by unliquidated damages? Unliquidated simply refers to an unknown quantity, an unknown sum, and damages refers to some form of monetary compensation paid to the defendant. So the main common law remedy under law of torts is actually unliquidated damages. So ultimately, what is a tort? A tort is a civil wrong, the remedy for which is unliquidated damages, and which is not exclusively a breach of contract or a breach of trust or any other equitable obligation. So look how Salmon's definition is also the same as the definition under the Limitation Act, but the only additional point over here is that he's talking about a remedy which is a unliquidated damages. Then we come down to Fraser. Fraser goes ahead to say that it is an infringement of a right in rem. Because again, come back to this flow chart over here. There's a civil wrong, which is a right in rem, and that breach of right in rem only is a tort. So Fraser also goes on to say that there is an infringement. That is, an infringement is nothing other than a violation of a right in rem of a private individual, which gives a right of compensation. What is compensation? Essentially, unliquidated damages at a suit of the injured party. Now, a suit usually refers to court proceedings. In civil law, whenever we're referring to a court proceedings under civil law, we call it as a suit. So that means someone has to institute a suit first in a court of law, and then the injured person has to tell the court, see, my right in rem has been violated, and as a result, I want a remedy which is compensation or unliquidated damages. And this is the definition given by Fraser. Winfield goes ahead to say that, again, tortious liability arises from a breach of duty fixed by law. Now, what is this breach of duty fixed by law? It simply translates to a right in rem, because every person is born with certain inherent rights that he gets protection for, and the law itself protects these rights of that individual. So, any kind of breach of duty, or duty of whom, or duty of the people to protect these inherent rights, will be punished, and the breach, that is the violation, is can only be remedied by paying some form of unliquidated damages. What is unliquidated damages? Ultimately, an unknown sum of money. So finally, what can we understand from this entire definition? That tort is a civil wrong, that it's an infringement of a right in rem, that the remedy in common law is an action for unliquidated damages. You cannot just go and demand unliquidated damages from the person. You will have to go to the court of law, institute a suit, and then only get compensation for the same. And finally, we can say that the tort does not include a breach of contract or a breach of trust. So if these three are clear, we'll move on to the remaining concepts. What do you mean by damage and what do you mean by damages? We need to understand that damage is very, very different from damages. We have seen and understood this even when we were studying interpretation of statutes. Damage refers to a legal, some kind of harm or loss, whereas damages refers to monetary compensation. So be very careful when you are writing the word damages in your answer sheets. You should not keep writing award damage, because award damage means you're giving harm to the other person. You have to write awarding damages. Now, there is a difference between liquidated and unliquidated damages. Liquidated damages simply means that there is a fixed or a known sum of money. Liquidated is simply a case of known sum of money. And unliquidated is basically an unknown sum of money. And in some cases, especially in contract, uh, the contract itself will say if there is a breach of contract, then the breaching party has to pay so much money to the other person. So a known sum of money is already provided. But what if someone trespasses into my property? If someone trespasses into my property but does not really do any damage, then I'll get very minimal compensation. But if someone trespassed into my property, broke everything, stole my flower pots, damaged my gardens, and then left, then the compensation will be much higher. Unliquidated or an unknown sum of money. Okay, so let's look at an example over here. They're saying that an action against the railway company for loss of goods in a carriage is due to the presence of a contract. So, what are they saying over here? When let's say that I want to transport my vehicle from Tamil Nadu to Karnataka, and I do so using the railway system. Now, when I go to the railways, I enter into a contract with them in essence that I hand over my car, they give me a slip, and then we enter into a contract for them to transport my vehicle from one state to the other. This is a contract. So when the railway company does something to breach the contract, that is, they do not deliver my car either on time or properly, then there is a breach of contract. Okay, so here we cannot say that such an action is a breach of tort. It is merely a breach of contract. But if a passenger of a railways had any injuries occurred due to negligence of the railway employees, it is a tort. Now, what is happening over here? You are entering into a train, you're taking the journey to your destination. In between, you get injured, either due to the train suddenly stopping or any such thing. In this case, there is no real contract between you and the railways, but rather a general duty of the railways to protect you. And since they didn't do that, there is a tort over here. So friends, we will stop here with respect to this half of the chapter. If you found this revision series to be helpful, I'd like your comments in the comment section below, and I'll see you in the next video.